For more on what this wide sweeping ruling means, I'm joined by Professor Katherine Franke. She is the director of Columbia Law School's Law, Rights, and Religion Project. Professor, thank you so much for speaking with us. While this case involved same-sex weddings and a Christian designer's opposition to them, its consequences are much broader than that. Explain to us who else could be impacted by this ruling.
Well, many of us who've been watching this case since it was filed a number of years ago were shocked, really, to see how broad Justice Gorsuch's opinion for the Supreme Court was. Not only did he find that there's a free speech right for a business owner like Lorie Smith in this case to say, I don't have to comply with anti-discrimination laws because I have an opinion that opposes them, but the court gave us no limiting principles for how this broad win for Lorie Smith would apply in other cases. It is so broad that any business owner could really say, I don't want to provide services to Black people or Black couples or Jews or people in interracial marriages or people about whom I have some opinion of them that I don't want to serve them. And that if the state tries to force me to serve them, then they're compelling me to associate or speak about something with which I disagree. So the limits of this decision are actually boundless in so many respects, and that's something that I think a lot of people are quite troubled by.
And many people are saying it would leave the door wide open for discrimination. Now, does this ruling place other laws protecting LGBTQ rights in jeopardy?
This ruling implicates pretty much any law, whether it's one that protects against LGBT-based discrimination or race discrimination, religion, national origin, to be sure. But its breadth could reach really any law. Say you had an opinion that climate change laws or laws in dealing with environmental justice or environmental protection, you don't agree with them. And the state compelling you to comply with them, force you to give a speech or a statement about those laws that you disagree with.
One interesting note in this case is that the plaintiff at the time didn't have an online business, and she hadn't been asked to build a website for a same-sex wedding, yet she ended up with a case before the Supreme Court. So basically, with a hypothetical scenario, how does that happen?
Well, in the law, we have this concept of standing, that in order to bring a lawsuit, you have to have suffered some kind of injury that you would then complain about to the court and ask for a remedy. And many people felt that the problem with this case wasn't so much the First Amendment issue as the fact that she actually hadn't been injured yet. And I think this case reflects what we've seen in a trend of Supreme Court cases, that there is an enormous sensitivity on the part of the majority of the Supreme Court to even conjured injuries to religious objectors to things like abortion or gay rights. And at the same time, the Supreme Court can't seem to be able to recognize in any form race or other kinds of discrimination.
Well, it's certainly a ruling that is striking a nerve with many, many people. Professor, thank you very much for your time. Columbia Law Professor Katherine Franke, thank you.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.